Thank you, Brian. All right, I'm delighted to be here, and our topic for the evening, which was chosen by the conference organizers, is equality in the U.S. Constitution. Let me say right off the bat that I'm going to restrict my inquiries into this topic to the original unamended Constitution, in other words, the Constitution of 1787. Now, that means that I am cordoning off from consideration such clauses as the 14th Amendment's guarantee of the equal protection of the laws, as well as the dramatic steps toward political equality brought about by the later amendments that secured the vote for African Americans, for women, and for young people. It also means ignoring those very early amendments, the first 10, called the Bill of Rights, whose purpose is to protect the equal rights of individuals from congressional infringement. My hope is that this deliberate narrowing of the inquiry to the Constitution of 1787 will still provide plenty for us to think about. Yet, I am compelled to admit that the initial signs do not look promising, since the word equality does not appear in the Constitution of 1787. Other abstract, capitalized nouns like justice, welfare, liberty do appear. Indeed, they're featured in the preamble as constitutional aims. The absence of any explicit reference to equality might be compared to another striking absence in the Constitution. The word slavery never appears there either. Yet we know that the institution of slavery makes itself felt in the text. For instance, the 3/5 clause. The distinction is drawn there between free persons and all other persons. Those other persons, presumably, are the enslaved portion of the population. The drafters of the Constitution had to grapple with this most extreme form of inequality, the division of inhabitants into free and unfree, when they considered how to count the population for the purpose of representation in the House of Representatives. We'll return to that dilemma later. For the moment, though, I want to keep the focus on the hunt for equality, rather than on the obvious problem of unjust and long-entrenched inequality. Although the word equality doesn't appear in the Constitution, some related words do. The words equal and equally do appear. Now, we might begin by noting that equal is a mathematical, quantitative term. To be equal is to be the same. The two sides of an equation are equal to each other, as in 2 + 3 = 1 + 4. Words like justice and liberty, those are thoroughly political concepts, but equality is an idea imported from the realm of measurable things. So, perhaps not surprisingly, it first comes to sight in those aspects of political life that involve counting people in the census, counting votes. Nearly every explicit reference to equal refers to the details governing elections within the various institutions of government that the Constitution establishes. Now, I'm going to proceed just in a really straightforward, literalist manner. I'm going to examine each of these instances in turn, and there are 6 of them. At least that's how we're going to start. So if you take a look at the handout, you'll see the 6 equal or equally clauses. All right, so first use of equal speaks of how to bring about the staggered elections of senators. In the interest of stable continuity, the drafters didn't want all the senators coming up for election at the same time. Only 1/3 of them stand for election in each 2-year cycle. Now, to achieve this spacing, Article 1, Section 3 specifies that the senators are to be divided as equally as may be into 3 classes. The qualification here, not equally, but rather as equally as may be, is necessary because numerical equality is only possible if the total number of senators is evenly divisible by 3. Otherwise, you have to settle for an approximation of equality, as we do now with how many senators? Someone in the audience? 100. Right? So this very first reference to the equal shows the difficulty of achieving precise equality when dealing with human beings. The number 100 can be divided by 3 to yield an answer of 33.333333, repeating, right? You put that little line above the last 3 to indicate that it repeats endlessly to infinity. But if you've got 100 senators, they have to be assigned to slightly unequal classes, 33, 33, and 34. So the Constitution's initial need to settle for approximate equality should maybe stand as a warning. If even simple numerical equality is often unattainable, what will the situation be when other types of equality, more political types, are sought? What about equal rights, equal opportunity, equal outcomes? Will they be more attainable? All right, second one. The next textual reference also relates to the Senate. Since this branch of Congress will always be composed of an equal number of senators, right, 2 per state, a way was needed to break a tie vote. Just as there are no ties in baseball, there are no ties in the Senate. The Constitution specifies that the Vice President of the United States shall be President of the Senate, but shall have no vote unless they be equally divided. Right, we're all very familiar with this clause right now because it's right in effect whenever you have a 50-50 Senate. This provision for what is called a casting vote, a vote that's exercised only in the special circumstances of a tie, shows yet another aspect of mathematical equality in a political setting. Voting always involves dividing into parts. Indeed, in the British system, a vote in Parliament is referred to as taking a division, since the members physically separate into areas called division lobbies. There's an aye and a no lobby, and tellers just count the bodies as they enter the lobby of their choice. When it comes to voting, the perfect equality of a 50-50 split is undesirable. Decisions require inequality, the inequality of a majority and a minority. For a bill to become a law, we need at a minimum to get to 50% plus 1. More weight has to fall on one side than the other side of the question. So interestingly, these first 2 usages of equal in our Constitution link equality, both of them, link equality with the mathematical operation of division. In the first case, the division of senators seeks to create equal classes. In the second case, a mode is found to remedy the dysfunction and the gridlock caused by a division into equal parties. I think we could sort of extract a large lesson from these first 2 instances. It seems that sometimes we desire equality, or as much equality as can be attained. Other times, we require inequality or hierarchy in order to function at all. And as we proceed, we'll see how the Constitution blends equality and inequality, or sameness and difference. Now, next reference, third one, found in Article 2, Section 1. It's a passage that describes the very complicated machinery of the Electoral College. In the construction of the Electoral College, each state is granted a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. The Constitution is kind of boring, you know, when you just read it. So it's only when we start to think about it that it gets kind of interesting. All right, so number of electors equal to the whole number of senators and representatives into which the state may be entitled in the Congress. The compound character of our system is on display here. The Senate is organized on the principle of state equality, whereas the House is organized more on the principle of one man, one vote, or it might be more accurate to say the House members represent the population as organized into districts. Right? House members are elected at the district level. Now, for election to the presidency, remember the presidency is the one office that in a way represents the whole nation. These 2 different principles are combined. Both the equality of the states and the equality of individuals are recognized and included in the determination of how many electors each state receives in the Electoral College. Now, there are two other instances of equal that appear in this section on the Electoral College. Rules are set forth for what happens if candidates have an equal number of votes. Now, some of the section has actually been superseded by the 12th Amendment. Remember, there was a kind of glitch in the original system, and it was possible for a tie between the president and the vice president to result, which actually happened in the election of 1800. But the basic rule still stands. A tie for president is decided by a vote in the House, and a tie for vice president is decided by a vote in the Senate. So once again, you see the danger of precisely equal votes. In order to settle an undecided election, the drafters resorted to a sort of fail-safe mechanism. Now, given that we have a system of separated powers, it's not really ideal for an election to be thrown to the House, right, to have the legislative branch determine the office holder of the executive branch, but it's better than having a constitutional crisis. Okay, the sixth appearance then, sixth and final appearance of equal in the original Constitution, appears in Article 5, where the unique structure of the Senate is made, in effect, unamendable. The provision declares that no state, without its consent, shall be deprived of its equal suffrage in the Senate. So, remember, each state accorded 2 senators, thereby the states are rendered equal, regardless of the differences in population. And those differences in population have become quite extreme. Wyoming has 500,000 residents. California has 39 million. But they're equal in the Senate. Why would Wyoming ever agree to sacrifice its equal suffrage? So that's what I mean by saying that it is unamendable. Right? The structure of the Senate is unamendable. This final instance confirms something that we might already have glimpsed. The states as political bodies are a prominent and permanent element of our mixed system. Federalism understood as the division of authority between different levels of government, is another word that doesn't appear in the Constitution, but the repeated references to each state, every state, establish and maintain the respective roles of the federal authority and the confederated parts. Right, I might now actually be done because those were the instances of equal and equally. But let's dig a little deeper. So maybe these words, each and every. Those are additional markers of equality in the Constitution. If a rule or a procedure applies to each one of something, then those entities are being treated equally. So here at Villanova, right, you get a syllabus. What's the syllabus say? Each student is expected to arrive on time for class. The professor is treating students equally by holding them to a uniform standard. Of the 18 occurrences of each in the Constitution, half of them relate to the states. So state equality is everywhere in the Constitution. It's there even in clauses that deny specific powers to the states. Equal prohibitions are another route to equality. Parents treat their children equally if they forbid each in turn to vape or drink or attend parties unchaperoned. Thus, Article 1, Section 10 lists all the things that the states cannot do, and the list is pretty extensive. The states are forbidden to enter into treaties with foreign powers. They're actually forbidden to enter into any confederation with other states in the Union. They're forbidden to coin money. They're forbidden to pass certain types of laws. So stripped of these formidable powers by the Constitution, the states are clearly not autonomous, sovereign entities. They are component parts, equally possessing certain powers and equally denied other powers. Indeed, the judges in every state are bound to uphold the supremacy of the U.S. Constitution. It's called the Supremacy Clause, over and against anything to the contrary in either state constitutions or state laws. So federalism exists under the umbrella of that Supremacy Clause. So we see once again that equality can be integrated with hierarchy or priority or inequality. Just as in the classroom or the family, the equality of students, the equality of children exists under the headship of the professor or the parents. And in our political order, headship or sovereignty belongs to the Constitution itself. Now, a less dramatic form of inequality is visible in our bicameral legislature. The Senate, by virtue of its smaller number of members and the longer term that they serve, is more elite. It was meant to be a more distinguished body. It's the upper house. Despite that deliberate inequality, there are several mandated forms of equality. For instance, each house is granted independent judgment over its procedures and its members. As a result, the Senate can't tell the House what to do about a member like George Santos, who gained his election through fraudulent misrepresentation of himself. Each House is also required to keep and publish a journal of its proceedings. Transparency is equally required, presumably so that citizens can carry out their role of refusing to re-elect the bums. Since the Constitution is a sketch of our institutional framework, it makes sense that equality appears in connection with these ingenious structures. The task of the drafters was to bring about a kind of equilibrium among the branches of government and among the levels of government. Equilibrium is an equality word also. You might know from your study of chemistry or physics that there's such a thing as dynamic equilibrium. Not static equilibrium, but dynamic equilibrium. The founders sought to achieve something like that, to construct a system of self-government in which actions and reactions could continuously occur without altering or destroying the fundamental balance. They relied on political insight and intuition. They specified the ways in which the states are equally subordinate, as in the listing of prohibitions, and the ways in which the states are equally protected, as in the guarantee of a republican form of government to every state in the Union. They even specified the ways that the states ought to interact with each other, as in the full faith and credit clause, which requires states to accord equal recognition to each other's public acts, records, judicial proceedings. Shifting from the states to the three branches of the general government, the drafters did things like add powers to the executive, giving the executive a veto over legislation. They did that to make the president more equal to the Congress. They divided Congress from within through bicameralism. They did that to lessen the danger of an overbearing unitary legislature. So the equality of the separate branches, right? They're trying to create a kind of equality, dynamic equilibrium among the three branches. That equality of the separate branches is not the natural result of their different functions. It is a feat of engineering achieved through the creation of what we now call checks and balances. All right, so we've got voluminous evidence of a concern with structural equilibrium. Does that mean that the Constitution does not recognize or care about the equality of individuals? There is one instance of each that has reference to individuals, but it is one of the troubling slavery clauses. So let's take a look at that. If you go to the section of the handout, I think it's probably the second page, slavery-related clauses. It is Article 1, Section 9. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. All right, this is called the Importation Clause. What it did was permit the states to continue to allow the arrival of new slaves until January 1, 1808, at which point Congress could and did ban the international slave trade. The personhood of Africans kidnapped and sold into slavery is clearly acknowledged in the passage. They are twice referred to as persons. At the same time, the grossest form of inequality among persons is allowed to continue, at least for the space of 20 years, until 1808. The element of equality that is present in the clause is that these persons who have been turned into commodities may, like other commodities, be subject to taxation, not exceeding $10 for each person. However, it should be noted that the provision to tax was meant to give Congress the ability to discourage those states who wanted to continue their involvement in the international slave trade, right? You know, you tax gasoline at a high level, you tax cigarettes at a high level. So this was intended to give Congress a certain power to discourage those states who wanted to continue their involvement in the international slave trade until the date arrived when Congress acquired the power to prohibit the trade outright. With the expectation that once the supply of new slaves from abroad was choked off, the institution of slavery itself would wither away. In light of the Constitution's repeated acknowledgement of the enslaved as persons, perhaps we can learn more about the status and scope of individual equality by examining what else the original Constitution has to say about persons. Most of the references to persons describe the eligibility requirements for the federal offices of representative, senator, and president. And the requirements are strikingly minimal. A person must have attained a certain age. Do you all know these provisions? How old do you have to be in the House of Representatives?
25.
Yes, thank you. Senate?
35.
Nope. 30. President? 35. Good. Okay. You have to be a citizen for a certain period of time. How long do you have to have been a citizen to run for the House? 7 years. Senate? Close. 9. And president? 14. Well, you have to have been resident. Who's talking? Resident for 14, but you have to be native born. Right. So you could be born in Panama, you know, you're an American citizen, but you have to have been resident in the U.S. for 14 years before you announce for the president. Okay, so you got to attain a certain age, you have to have been a citizen for a certain period, and you have to live in the locale that is being represented. But this means that at least on paper, office holding is open to nearly all citizens. And the federal standard is much more broad-based than the standards for state office. So today, for instance, to run for governor of Missouri today, you have to have been a resident of the state for 10 years. Whereas you could move to Missouri and announce a run for the Senate the very next day. Both Robert Kennedy in 1964 and Hillary Clinton in 2000 were elected senators from New York as basically out-of-state candidates. So those who are eligible for federal offices are called persons with no exclusions based on wealth or gender or race or religion. In fact, the Constitution states explicitly that there is to be no religious test for any office or public trust under the United States. So from the beginning, participation in government was conceived in a remarkably democratic way. Now, of course, the state of society was such that we did not see black federal office holders until after the Civil War. We didn't see women in federal office until the 20th century. But whatever the degree of societal discrimination, it was not enshrined or made permanent in the fundamental law of the land. The standard established is egalitarian, with judgments of candidate quality being left to the voters to determine. The voters are trusted to discern and reward merit wherever found. So, what's the next question? Voters? Who are the voters? That's the essential question. Remember that voting itself is a form of office holding. Aristotle tells us this. To vote means to partake of deliberation and decision. In a representative system like ours, this office, right, is performed only periodically. Citizens are not daily voters in the assembly, as in the small direct democracies of ancient Greece. Instead, citizens are electors. Okay, that's the name of the office that you all now hold. You are an elector. Periodically choosing those who will represent you. Now, what does the Constitution say about electors? Well, the Constitution does not establish a uniform national standard for electors. Instead, it defers to the existing state standards with the proviso that whoever can vote for the most populous branch of the state system can vote for their congressional representative. So this is a rule that acknowledges the diversity of the states, but at the same time, I think you can argue that it pushes in a democratizing direction because it ties federal voting to state voting for the most democratic branch of the state system. So here in Pennsylvania, which is the most populous branch of the state system? Are you guys Pennsylvanians? Nobody's a Pennsylvanian? Okay, where are you from? Where are you from? Me? In the maroon sweatshirt here. Okay, so what's the most populous branch of your state system? Oh, you can tell me. What does it mean to be, in other words, which branch has the most folks in it? You got a governor, right? That's just one. Sure. Do you have bicameralism? Are there two houses in the state system? Yeah. I bet there are. Yeah. Do you know what they're called? The Senate and the House. Ah, so same as the federal system. So which is the more populous of those branches? The House. Right. Okay. So in Maryland, it's the House of Delegates. We use an older term, not the House of Representatives, House of Delegates. Okay. So at the time of the founding, who qualified as an elector varied widely among the states. Some states had property requirements for electors, Virginia, for instance, with the amount of property ranging from minimal in some states to pretty significant. I think it was pretty significant in Virginia. But there were others that had no property requirement at all, even at the time of the founding. In some of the states, free blacks, remember 1/10 of the black population was free. That was a pretty steady number that held through the years. Free blacks exercised the suffrage at the time of the founding. We know that there were black citizens who voted to elect delegates to the ratifying conventions for the Constitution. Right? They were emphatically part of we the people. But in other states, they could not. In the very early years of the Republic, women voted in New Jersey. At the time of the founding, women voted in New Jersey. Later, but still before the passage of the 19th Amendment, women voted in many of the states out west, but they usually did not vote back east. Although sometimes there was a kind of customary practice whereby widows and self-supporting single women who were heads of household did vote. In other words, the understanding was that the vote was a kind of a household vote. Right, so if the situation was such that a woman was head of household, she could vote. So deferring to the states in this way meant accepting a great deal of variability. And variability means inequality. Now, those inequalities were substantially lessened over time with the adoption of the 15th, 19th, 24th, and 26th Amendments. Now, I said I wasn't going to talk about those later parts of the Constitution, but let me just say something really quick about them. It's important to remember that in no case did those amendments grant the privilege of voting to new groups. The language in each of them suggests that citizenship carries with it the expectation of the vote, the franchise, the suffrage. Accordingly, one should never say that the 19th Amendment gave the vote to women. What the amendment says is, and I put all of them in there, you can see that the language is identical. It's kind of formula that is followed in all four of those amendments. What the amendment says is that the right of citizens of the United States to vote shall not be denied or abridged on account of sex, or on account of race, or on account of, being a certain age. I can't remember the formulation that they used there to specify, 18 and over. So I think the implication in all of those cases is that women as citizens, blacks as citizens, 18-year-olds as citizens, all along had the right to vote, but that it was being abridged or denied. So from the 19th Amendment forward, the vote for women is protected. The vote is not granted. It is secured for a previously unprotected category of citizen. Now, there are other abridgments of the right to vote that we still allow. For instance, states abridge the right to vote for those under 18 years of age. They can make voting contingent on a residency requirement of varying lengths of time. They can deny the vote to persons convicted of a felony, either during incarceration or permanently. So the constitutional clause that links voter eligibility to existing state regulations is still in effect, as modified by the four franchise-protecting amendments. Okay. Now, as we've already seen, the Constitution issues both guarantees and prohibitions. In many cases, the direct beneficiaries are individuals, and what they gain is equality before the law. This is especially true of the prohibitions that apply at both the federal and state levels. So here, take a look on the top of page 2, equal protection of the law. Article 1, Section 9 declares no title of nobility shall be granted by the United States. That injunction is then extended to the states in the very next section, which says no state shall grant any title of nobility. Now, I think we are so accustomed to living in a society characterized by what Alexis de Tocqueville called equality of condition, that we've forgotten just how significant this ban on titles of nobility is. All the countries of the old world, whether in the West or in the East, were caste systems, hereditary ranks, right? The European nobility and peasantry. Look at the Indian caste system. Most people have sort of heard the term Brahmin, right? It was actually a four-tiered system. Brahmins at the top, a warrior class, a merchant class, the commoners, and then another category, the Dalit, or untouchables, who were so low that they were considered outside of the caste structure altogether. The founders wanted to ensure that nothing like this could be instituted in the New World. Now, certainly, they expected there to be economic inequality. Some degree of inequality is an inevitable byproduct of liberty. When we today speak of different classes, right, based on varying amounts of income. Those are sociological terms of convenience, right? Terms of sort of analysis. They're not legal categories with distinct rights or privileges or obligations or burdens. Right? Being in the middle class, right? It's not an inherited status. Those born into one income quartile often move up or down into another with the vicissitudes of economic life and family life. So the political task is to ensure that economic inequality is not a function of unfreedom, as in systems where status is immutably assigned at birth. Now, of course, American slavery was the one great exception to this equality of condition. In reducing persons of one skin color to slavery, those of the other color were artificially elevated. Frederick Douglass, for instance, said that slavery created a skin aristocracy. A skin aristocracy, which affected all whites, not just the small number of slaveholders. And remember, there really weren't very many slaveholders. They were the 1%ers of their day. But Douglass pointed out this affected all whites who shared in this skin aristocracy. But I think it's crucial to understand that whiteness as an entitlement to privilege was neither brought into being nor ratified by the Constitution. In fact, Frederick Douglass asserted that the Constitution was the best weapon against any attempt to translate white privilege into law. Justice Harlan would take this line of reasoning in his famous dissent in the 1896 case of Plessy v. Ferguson. Remember, that was the segregation case where the majority decision of the court was to enshrine separate but equal as an acceptable, as constitutional. Harlan argued against that, and here is how he put it. Harlan stated that in view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are involved. Almost as important as the ban on titles of nobility are the clauses that forbid bills of attainder and ex post facto laws. These are essential protections against legislative malfeasance, and as with the ban on titles of nobility, the language is repeated first with reference to the federal government, the national government, and then with reference to the state governments. The ban on bills of attainder insists that each new generation be treated equally. It recognizes a kind of principle of generational independence, a kind of right to a fresh start. Now, of course, children will always be influenced by the character of their parents and the circumstances of their parents. As we know, that influence can be advantageous. It can also be disadvantageous. And in that sense, the generations are interdependent. However, legal disabilities should not be extended to the next generation. So, for instance, a parent convicted of a felony might forfeit the right to vote, but because of the ban on bills of attainder, that punishment cannot be extended to other family members. In the decades before the Civil War, there were radical constitutional thinkers like Lysander Spooner and Frederick Douglass, and they both argued that inherited enslavement was actually a bill of attainder because it punished future generations by entailing the mother's miserable condition onto her offspring. And they suggested that the constitutional ban on bills of attainder could have been used to challenge and overturn the legality of slavery in the southern states. Although the strategy was not tested in the courts, I think you can start to see what Douglas meant when he declared that the Constitution was a glorious liberty document that ought to be wielded in behalf of emancipation. Now, this conception of our frame of government as providing effective tools to protect individuals, I think it is not at all at odds with the founders' intentions. Madison, for instance, originally argued that the Constitution didn't actually need an additional Bill of Rights because the original Constitution was already a Bill of Rights. Remember also that the eventual adoption of the first 10 amendments, which protected certain designated rights against congressional infringement, it did not protect them against state infringement. Think of the First Amendment, right? Congress shall make no law, abridging freedom of press and speech and all of that. So the doctrine of incorporation, whereby parts of the Bill of Rights were made binding on the states, that didn't emerge until much later. But the elements of equality before the law that are present within the original Constitution, those did restrict both federal and state governments. The ones that I've just mentioned. Let me mention one other one. Along with the safeguards that I've already mentioned, there are constitutional provisions to protect the rights of the accused, such as trial by jury, and crucially, the privilege of the writ of habeas corpus. Now, the writ of habeas corpus was deployed successfully by anti-slavery forces to actually end slavery in England. It was the Somerset case of 1772. The writ of habeas corpus was also the linchpin of the Amistad case. Have you seen the movie? I think it's just called The Amistad, isn't it? Movie about this case. It was a case that came before the Supreme Court in 1841. It was actually argued by John Quincy Adams. And Adams succeeded in gaining freedom and returned to their homeland for a group of recently kidnapped Africans from the Mende tribe. They'd been kidnapped, they were on a Spanish slave ship, they managed to seize control of the ship when it was in the Caribbean, and then they sort of got lost and were found in American waters. So it's not for nothing that the writ of habeas corpus is known as the Great Writ. Okay. Our quest for equality in the Constitution is wrapping up, but I do want to suggest one final spot that we should examine. And it may be that you all thought of this first and have been wondering what I was doing in these other waters. I began the inquiry by noting that equality is not one of the explicit aims mentioned in the preamble. But maybe that is because equality was already there. Maybe equality is in the Constitution as its premise, as its starting point, rather than its aim. The opening words of the Constitution are, "We the people of the United States." As Daniel Webster thunderously put it in his second reply to Hayne, it is, sir, the people's Constitution, the people's government, made for the people, made by the people, and answerable to the people. That still forces us to ask the question, who is included in that we the people? Just as today, there were some in the past who believed that the term was more exclusionary than it sounded, or that it could be given a new exclusionary interpretation. Particularly in the decades leading up to the Civil War, a battle developed over the text of the Constitution and the text of the Declaration. Frederick Douglass was a prominent figure in that struggle. Throughout the 1850s, Frederick Douglass fought hard to restore the document's original meaning, which he believed was inclusive and essentially anti-slavery. So here is Douglas's explication of the term people, which he insisted should be interpreted in a plain, common sense way. Here's the quote. Neither in the preamble nor in the body of the Constitution is there a single mention of the term slave or slaveholder, slave master, or slave state. Neither is any reference to the color of any part of the people of the United States. We the people, not we the white people, not we the citizens or the legal voters, not we the privileged class, and excluding all of the classes, but we the people, not we the horses and cattle, but we the people, the men and women, the human inhabitants of the United States, do ordain and establish this Constitution. Now, Douglas was aware that many of the founders were slaveholders, but he also knew that they had forcefully denounced slavery as unjust and had taken meaningful steps to end it. He knew, too, that there were a few clauses in the Constitution that could be and had been interpreted as concessions to the slaveholding interests. He used, I think, a helpful metaphor. He really had a kind of genius for these metaphors. He used a metaphor to explain the role of such clauses as the importation clause and the 3/5 clause. Here's what he said. If in its origin slavery had any relation to the government, it was only as the scaffolding to the magnificent structure, to be removed as soon as the building was completed. In calling these clauses scaffolding, Douglas indicated that they were necessary, but temporary and ugly. Necessary and temporary and ugly, meant to be torn down and cast away. Based on his study of the history of the founding era, Douglas confidently announced all, at that time, looked for the gradual but certain abolition of slavery and shaped the Constitution with a view to this grand result. The fact that slavery had not been eradicated, right, the scaffolding had not been torn down, that was not the fault of the Constitution. It was instead the unanticipated consequence of later technological and economic developments, compounded by the eternal temptation of human greed, and then rationalized by the emergence of the pseudosciences of ethnology and phrenology and scientific racism that emerges by the mid-19th century. Whereas the Bible proclaimed that God made of one blood all the nations of the earth, and that humankind is made in the divine image, the new ideology of race-based hierarchy held that different human types were so separate as not to belong to a common human species even. This supposedly scientific theory of polygenesis was the ultimate denial of human equality, dreamt up to justify the permanent enslavement of so-called inferior races. But this kind of pernicious race theorizing was actually not in existence during the Revolutionary era. It didn't take hold in the United States until the 1840s, 1850s. So when the drafters of the Constitution began with the phrase, "we the people," they were echoing the language of the Declaration of Independence, right, just a decade before, thus linking together the two foundational charters of our national existence. And equality is pretty much the whole point of the Declaration. I've included the two opening paragraphs there of the Declaration. If you just take a quick look at them, I'll just say a word or two. So if the Declaration, with its natural rights philosophy, is in the background of the Constitution, then a very clear grasp of equality is in operation there. So just a quick review of those two paragraphs. The first thing that we're told in the Declaration is that the 13 United States constitute one people In other words, if you want to know what a people is, right, we the people in the Constitution, you go back to the Declaration, tells you what this one people is. And independence is the act of one people who take the initiative to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. So the first form of equality in the Declaration is the equality of sovereign peoples or nations. Despite the vast power of the British Empire, the newly born, the infant United States of America is entitled to an equal station. Now, obviously, it's not equal in strength or wealth, but it claimed that it was deserving of basic respect as a political entity. Our claim, made 250 years ago now, is the very same claim that Ukraine makes today, right, against its aggressive and revanchist neighbor, Russia. But it isn't only peoples and the distinct political entities that they choose to form that are entitled to equality. In its even more famous second paragraph, the Declaration goes on to explain the political convictions that unite the one American people. And this one people, how is it formed? It's not formed by race or ethnicity. It's not formed by religion or language. It's not formed by culture or history. Rather, we are that particular people who believe in a foursome of truths that transcend particularity. We hold it to be true and self-evidently so that all men are created equal. Equal how? Equal in what respect? Well, maybe equal in having been created. Equally endowed by a creator God with inalienable rights, including the right to liberty. So the claim is not that all human beings were then enjoying their natural rights. Most of them, not just the slaves, but the colonists as well, were not enjoying their rights. That, after all, is why they were separating themselves from the oppressive mother country, from England. The claim is that all human beings have a right to liberty, and then further, that the purpose of government is to protect those pre-existing but often violated inalienable rights. So a decade later, when the Constitution declared that its purpose is to secure the blessings of liberty to the people of the United States and to those who come after them, their posterity, it incorporates, so to speak, the natural rights teaching of the Declaration, a teaching that begins from the equality of persons and the equality of peoples. Abraham Lincoln, who is, anytime I talk, I have to quote from both Douglas and Lincoln. So now I'm going to quote from Lincoln, and then we will conclude. Abraham Lincoln, like Frederick Douglass, is one of the best guides, I think, to the meaning of our founding documents. And Lincoln explained the essence of the Declaration as the principle of liberty to all, the principle that clears the path for all, that gives hope to all, and by consequence, enterprise and industry to all. So Lincoln really understood the expansive promise of that word all in the Declaration. The promise was not even limited to the one people who declared their equal independence. It was global in scope. Lincoln explained the intention of the founders this way. They meant to set up a standard maxim for free society, which should be familiar to all and revered by all, constantly looked to, constantly labored for, even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influence and augmenting the happiness and value of life to all people of all colors, everywhere. In closing, let me just suggest that the task for us today is not to judge the past as harshly as we sometimes do, but rather to examine ourselves more critically, to see whether we are holding true to the demanding trajectory established by the Constitution of 1787 and the Declaration of 1776. Are we still dedicated to the egalitarian principle of liberty to all?